Good morning and welcome to the Court of Appeals. Takes us a moment to get rearranged up here. Before we call the first case, I want to take just a few moments and talk about our procedure and just make sure everybody's on the same page. Obviously, we have experienced practitioners here, but it always makes me feel better if we do at least talk about the ground rules. Each side gets 15 minutes to make its oral argument. If you are the appellee, well, I've got ahead of myself. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've come to the podium and introduced yourself, but before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. If you're the appellee, you obviously don't get any rebuttal time. We have a lighting situation on the podium. You have 3 lights, green, yellow, and red. So long as the light is green, and it will become green when you begin your argument, you have plenty of time. Once the light turns yellow, it is indicating to you that you're running out of time, and once it turns red, you're out of time, and we ask that you please respect those time constraints. One of the most important things for everyone to understand is this. These arguments are being live streamed. So think about what you say before you say it, because once you've said it, it's out there for the entire world to hear. We've had some situations in the past where people perhaps have rethought what they should have said and wish they hadn't said it. So please think about that. Your panel today consists of Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Clerk, we have anything to take up before we call the first case?
Give me just a moment, Your Honor. It's saying no volume. Give me just a second.
Okay. Technical difficulty. We good to go?
Just a moment. They were messing with something the other day. So
Okay. Are we ready, or do we need to wait?
just a moment.
Okay.
Just a moment. For some reason it says the volume's really low, so I'm not sure if it's picking you up as loud as it should, so. We're checking on it right now.
Right. It's a byproduct of being live streamed. We have to make sure everybody's on the same page.
Okay, we're good to go.
Okay, all right. You may call the first case, please.
Clarksville, Montgomery County Education Association versus Clarksville, Montgomery County Board of Education.
And we will hear from the appellant.
Morning, Your Honor.
Good morning.
I am Mark Nolan, and I represent Clarksville, Montgomery County Board of Education, the original defendant in the lawsuit, the appellant here today. And I would like to reserve 3 minutes for rebuttal.
3 minutes. All right, sir. You may proceed.
Yes. When we were in law school, you probably heard, if you have the facts on your side, just argue the facts. If you have the law, just argue the law. If you don't have either, just argue. And I would submit today that there's a kind of a fourth category. Let's talk about legislative intent. Because I don't think that either party is going to dispute the basic facts about how we got here. And I would submit to the court there's really not any case law that controls this case. This is largely not been before the court on any issue interpreting these particular statutes. And this is a case that, although it originated out of Clarksville, Montgomery County, has the potential to have statewide reaching effects depending on how the court rules on the motion. So obviously what we are asking the court to do is overturn the chancellor's decision. And so we're interpreting the statute on the PECA, which is the Professional Educators Collaborative Conferencing Act of 2011. So there was a decision that the chancellor made, and we believe that he has taken his decision too far, and it has a very far-reaching effect. So let's talk a little bit about that. And of course, originally this lawsuit is over collaborative conferencing. And so the facts are going to be that every district must have a student code of conduct. Clarksville, Montgomery County is no different. They have student code of conduct, have one every year. It's reviewed every year. It's modified every year. Sometimes the legislature changes the law. Sometimes there's tweaks to things that need to be made. And so those changes are made every year. And up until the 2020 change, there had never been any discussion in collaborative conferencing over changes to the student code of conduct. It had just never come up. And we submit that it didn't come up because it wasn't appropriate to discuss in collaborative conferencing. So that's the issue. In this particular year, there were changes made, and of course the plaintiff complained and said you didn't include us in collaborative conferencing, and the chancellor, after hearing arguments and motions for summary judgment, ruled that we had violated the Collaborative Conferencing Act by not including this as part of the discussion with the Teachers Association. So,
Excuse me for a second. At any point during collaborative conferencing, I know you said not this year, but at any other point, had student code of conduct been included?
No. And in each of those years where we had done it before, there were memorandums of understanding that were reached, and student code of conduct was never in any of those.
Okay,
so
thank you.
So by history, no, that had not come up before.
Who gets to decide what's discussed? Is that part of the record?
It is, and it's also part of the statute. So, and so, let me kind of just go through. Here are the statutes that I think are relevant that the court is going to need to look at for guidance. Of course, we're going to start with 49-5601, which is just the start of the statute of the Professional Educative Conferencing Act of 2011. Once we get past that, then we start looking at definitions. So 49-5602 starts having some definitions. What is collaborative conferencing? What is a memorandum of understanding? Those are defined in there. What we're really going to talk about is what is a working condition. So working condition under Part 13 is defined in the statute as working conditions of professional employees or terms and conditions of professional service means those fundamental matters that affect a professional employee financially, or the employee's relationship with the Board of Education, and are specifically designated as such under this part. The term working conditions or terms of conditions of professional service is intended to be narrowly defined. It does not include any matters not specifically designated in this part. So the legislature has told us when they adopted this act, we want this interpreted very narrowly, and it must meet these criteria. So we look at what are those criteria. Your 49-5608. It is now defined. Salaries, grievance procedures, insurance, fringe benefits, leave, payroll deductions, and working conditions. So now we have a definition of working conditions, and it says working conditions except those working conditions which are prescribed by federal law, state law, private act, municipal charter, rules, and regulations. So do we have any state law that might apply here? The answer is yes, we do. the legislature, and again, this court, there's plenty of cases that say this, we are to assume the legislature knew what it was doing when it did it. That if it says something in there, it says it for a reason. So they adopted a statute of how the student code of conduct should be adopted, and they specify it. In development of the, and this is in 49-6-4002C, in developing a discipline policy, the local board of education or charter school shall seek recommendations from parents, employees of the LEA, law enforcement personnel, or youth-related agencies in the community. Now, so it says, and the court found that we complied, that the district complied with this statute. It did the things that were required of it to adopt a student code of conduct. It's voted on by the board. They sought recommendations from parents, employees, and the way they sought recommendations by employees, they sent out surveys to principals, they got information back. They sent surveys to teachers who identified by the principals, and they got information back from the teachers. They made changes to the code of conduct. And the issue here is, in this particular year, the change was Clarksville Montgomery County School System had a student code of conduct, and it was based on points. The effect of that was, if you accumulated enough points, you got suspended from school. You could accumulate enough points for talking in class and doing a lot of minor infractions, which was resulting in a disproportionate number of people being suspended for minor things versus big things. So it was changed to a level system. So that's the change in the student code of conduct. We've gone to a level system. And so the issue is, it was codified as to what teachers were doing in the classroom, but now we've written it down. So we put in the student code of conduct, who's going to be responsible for administering discipline for certain categories of offenses. Well,
Doesn't that affect, though, the teacher's discretion?
I mean, I would say no, and here's why. The student code of conduct is controlling the actions of the students, not controlling the actions of the teachers. The case that was cited before was Polk, which was controlling the dress code of the teacher, and the court, under a prior law, found that it was a working condition for the dress code. But here, the application of the control is of the students. It is telling the student, level one, that classroom teacher may be the one to address you, stop talking, put your phone away. That's what's been going on since the beginning of the time. The classroom teacher is the one that is controlling the classroom.
But I guess my question, I'll try to be more specific.
Okay.
This seems to me, the analysis seems to be more of, we have an objective standard or we have a discretionary standard. A teacher can do something about this, points are incurred. A teacher doesn't do something about this, points aren't incurred. Does the teacher's use of that discretionary ability, again, I'm thinking and talking at the same time. The question of the teacher's discretionary ability, can it have an effect upon the teacher's employment status or financial status?
No, and so here's why I say that, and the chancellor asked that. Can a teacher be disciplined? If the teacher is disciplined, there's a separate procedure for discipline of tenured teachers. There's laws on that, and that actually is covered in collaborative conferencing about discipline of teachers. If a teacher just said, I'm not going to apply the student code of conduct, I'm going to be insubordinate, they're not being disciplined because of the student code of conduct. They're being disciplined for being insubordinate.
Well,
Just,
let me change the question just a bit. You said, I'm not going to apply. What about how the teacher applies the code of conduct?
well, the teacher is giving guidance as to what they are to look at, but again, they're controlling the classroom, but the problem is now we make everything, if the court's interpretation is right, we've expanded working conditions. Let's say that we have a set point on a thermostat and it says no heaters in the room. I'm cold, so I bring in a heater. I'm now being insubordinate. I have not followed that law, so now that's a working condition. The legislature said interpret it very narrowly, and so that is what we are doing. And it also says,
I understand what the legislature said, but I'm talking about the actual implementation or effect of the code of conduct. In other words, if one teacher would say, okay, I'm going to, for want of a better word, cite you and you get these points because you've done this. But another teacher looks at it and because of experience or whatever says, I don't believe I'm going to cite that person. So there are no points incurred. There is no conduct or no ramifications from that conduct. Can the teacher be at risk because of that?
the teacher isn't at risk unless the teacher is trying to be defiant and just say, I'm not going to manage my classroom. So they're not being disciplined because of the student code of conduct. They may be disciplined because they're not acting as a teacher. And I'll say one thing, and I've got to sit there.
What's the difference?
Well, management of classroom is a professional duty.
Without a doubt.
And the legislature said under 495608B5, no other terms or condition of employment shall be the subject of collaborative conferencing between the Board of Education for personnel decisions or professional duties. It specifically says this type of thing cannot be part of collaborative conferencing. So the way the legislature is very specific, it excludes professional duties for collaborative conferencing.
You've used your time. You've got your rebuttal. Thank you. Hear from the appellee.
Good morning, I'm Rick Colburn. I represent the Clarksville Montgomery County Education Association, the acronym CMCEA. I may refer to them as that. The other acronym I may use is PECA for the Professional Educators Collaborative Conferencing Act. The issue in this case is whether some changes, not all changes, but some changes to the student code of conduct affected teachers' working conditions and therefore were subject to collaborative conferencing under PECA. Some of the revisions that affected teachers were primarily the revision of putting offenses into different categories and specifying that Category 1 offenses, which are the most common disciplinary offenses by students, were to be handled by teachers. Before these changes were made to the code, there was no consistency in how discipline was handled from one school to the next. Many times students were simply referred to the administration of the school, the principal's office, for discipline. These changes to the student code of conduct made it part of the teacher's daily work to handle all of the Category 1 offenses. In addition...
So let me ask you this. Is it your position that under the prior system, teachers weren't responsible for doing any internal classroom management?
No, that's not...
Because that's kind of what it sounded like. You said some of them could send them to the principal and some of them could do what they wanted to with them, but some things are just in the classroom, internally controlled in the classroom.
Right, and that's not our position, but the record reflects, and this was in the Rule 30.026 deposition that we took, which is in Volume 4, I think, of the record. The record reflects that Part of the impetus for these changes to the student code of conduct that brought us here were to be more systematic about what offenses are handled by whom, because it wasn't systematic throughout the school system. It was handled different ways by different administrators and different teachers, and one of the goals here was to take all of the category, the most common disciplinary problems, and have those handled in the classroom by the teacher, not by a referral to the office. And then the other part of this was there was an emphasis on social and emotional learning supports for students that was a part of this new student code of conduct, and teachers were given responsibility and were even encouraged to take professional development to help them with providing these social and emotional learning supports for students. So while these code revisions were being developed, the CMCEA and the board were in the midst of collaborative conferencing. And student conduct is one of the things they were talking about. There was a Vanderbilt survey that dealt with student conduct issues and talked about the effect that student misconduct and teachers having to deal with student misconduct had on the adverse effect that it had on learning and teaching. And so the CMCEA desired to negotiate these changes in the student code of conduct, but they weren't given the opportunity to do that. There was a separate code committee that the board put together to develop these changes to the code of conduct. That code committee did inquire of 120 teachers that were handpicked by principals rather than negotiating with the CMCEA, which were the representatives that had been picked by the teachers to represent them in collaborative conferencing. What this case really does come down to is how the courts are going to define working conditions, which is a mandatory subject of negotiations under PECA. School boards and teachers have been negotiating working conditions since 1978, when the Education Professional Negotiations Act became law. But it wasn't until 2002 that there was any real definition given to the term working conditions. The first endeavor to define it came from the Court of Appeals in the Blount County case in 2002, and the court there said working conditions was not synonymous with terms and conditions of employment and applied only to conditions for work, which my description of that is light, heat, air, the physical conditions for work. The legislature promptly overruled, if you will, the Blount County decision in Chapter 683 of the Public Acts of 2002 and defined working conditions as synonymous with terms and conditions of employment, and said it encompassed those fundamental matters that affect a professional employee financially or affect the employee's employment relationship with the board. The scope of working conditions was then addressed. That definition was adopted by the Court of Appeals in the Polk County case, which is a 2004 case cited in both our briefs. And there, the issue was whether a dress code for teachers was a working condition. And at first, the Court of Appeals sent the case back to the trial court. The trial court had said it wasn't. The Court of Appeals sent it back for reconsideration in light of this new legislation. The trial court still said it wasn't. So on the second time in the Court of Appeals, the Court of Appeals reversed the trial court and held that the dress code was a working condition. The court there looked at cases from other jurisdictions and explained that there wasn't a bright line that separated working conditions from matters of educational policy, and whether something was a working condition had to be resolved on a case-by-case basis. In this particular situation, the court held that because the penalty for non-compliance could adversely affect a teacher's employment relationship with the board, the dress code fit within the scope of working conditions. PECA was passed in 2011, and working conditions remained a mandatory subject of negotiations in PECA. The legislature basically carried over into Section 49.5.602.13 that same definition of working conditions that the legislature had developed back in 2002 in the EPNA. Now, the statute does say that the definition is intended to be narrow, but I respectfully submit that that narrowness can't eliminate working conditions altogether as a subject of negotiation. Otherwise, the term would have no meaning, and legislation can't be interpreted to have no meaning at all. I think.
What does it mean then?
Well, you know, I think the reason why the legislature put that language in there about it being narrowly construed is under the EPNA. The EPNA was the predecessor statute. It was modeled after the National Labor Relations Act. And under the state law, the EPNA, and the National Labor Relations Act, there were mandatory subjects of negotiation, and then there was everything else, which were basically permissive subjects of negotiation. And in PECA, the legislature, the goal of the legislature, one of the goals was to do away with permissive subjects of negotiation. So there are none. Now the collaborative conferencing, which is it's another name for interest-based bargaining. It's a particular style of negotiation, but it's only over the 7 mandatory subjects that are listed in 49.5.608, and there is no bargaining over permissive subjects. And I believe that this language about how narrow working conditions are to be construed was to ensure that the term wasn't used to effectively bring back in the negotiation of all these permissive subjects of bargaining that the legislature was trying to do away with under the guise of working conditions. But the Polk County rationale wasn't about permissive subjects. It was about what falls within the scope of working conditions. And we think that the case here is even stronger for treating these changes to the student code of conduct as a working condition than was the case with the dress code in the Polk County case.
So you're suggesting that the new legislation subsequent to Polk County didn't change anything?
I don't think it changed anything about what working conditions are. I believe that's true. I'm not going to say it didn't change anything. It changed a lot because it did away with permissive subjects of bargaining.
The analysis of working conditions.
I don't think it changed anything about the analysis of working conditions because it retained the same definition as those fundamental matters that affect a teacher financially or affect their employment relationship with the board. And that's what the court was looking at in the Polk County case. That was the same definition that the court was using in the Polk County case. And in this case, again, dealing with student conduct is a part of a teacher's daily work. The evidence is undisputed in the record that dealing with student discipline takes away from teaching and adversely affects a teacher in their primary work of teaching. Adverse effects on teaching and learning, it doesn't take much to imagine how that can affect a teacher's employment relationship with the board if it results in poor test scores by students, which affect teachers in their evaluations and can affect their employment in every way possible.
Let me ask you a question, and I guess I'm having a hard time making one of these connections here, but whether the teacher is under the older procedure, the points system, or whether they're under the step system, and I'm assuming in the step system that you have to have step 1 before step 2. The student has to go through step 1 before they can be sent on to step 2 or step 3.
But I mean, it's categories of severity of the offense is what, I think that's what the categories are based on.
All right.
So-
Well, so either way, the teacher is having to control his or her classroom,
That's right.
and they're having to maintain control. Now, how they choose to do so may vary from teacher to teacher, and what bothers one teacher or what one teacher considers to be an infraction or an offense, another teacher may not consider to be that big of a deal. But ultimately, the teacher has to discipline the class
Right.
in one form or another. And how is it different going to a new system? How is this really changing the fact that the teacher's got to discipline the class to have class? And I agree with everything you're saying about how discipline takes away from instruction time. I used to be a teacher many years ago. So I agree with that completely. But discipline's discipline. Whether you call it the point system or whether you call it the step system, you got to do it either way.
Right.
So I guess, like I said, I'm not seeing that
Well,
this is a change to the teacher's working condition. They've got to discipline kids, period.
well, it's a change to the policy, and it affects teachers' working conditions. Because, again, Mr. Nolan acknowledges, he was asked the question by the chancellor, and it's in the transcript from that proceeding is in volume 3 of the record. But he was asked if a teacher can be disciplined for not complying with what the policy requires, and he acknowledged that a teacher can be. Now I understand there was a question about the fact that this was not something that the teachers asked to engage in collaborative conferencing on before, and that's true. There's really nothing in the record that I'm aware of that explains why they didn't ask to do it before, but this was a substantial change in the student code of conduct because of the way it categorized offenses and the way that it made it very clear that teachers are going to have these responsibilities with respect to this long list of Category 1 offenses, and teachers are going to have these responsibilities with respect to the social and emotional learning of students in disciplinary situations.
So I guess my next question will be, if the teacher does not discipline students, if they just say, I'm not going to do it, how, just like Judge Stafford asked earlier, how does that not go to professional duty, a violation of a professional duty, which I believe is exempt from your collaborative bargaining?
Well, I mean, I don't know that that's completely exempt from collaborative conferencing, but again, I would suggest that the answer to these questions, you can really see the answer in the analysis by the court in the Polk County case. And this is over on, it's near the end of the Polk County case. And the court said, we conclude this particular dress code doesn't require teachers to purchase a new wardrobe, but it's unclear from the record what would happen to the teacher who did not or could not or would not comply with it, and this could very well fundamentally impact the teacher's employment relationship. The dress code is silent as to how the policy is going to be implemented and enforced and what the proposed penalty would be for noncompliance. And the court, because of that, said that the dress code policy could impact the teacher's employment relationship with the board and therefore fell within the definition of working condition. That part of the definition has to mean something.
Thank you.
Let me ask you,
Yeah, go ahead.
Ms. Colbert, under the change to the code of conduct, what was required on the part of teachers that was substantially different from what was required of them under the old code of conduct?
The two things required of them was the new emphasis on social and emotional learning supports, which the teachers were responsible for. That was not in the previous code of conduct. And then the other thing is the categorization of offenses into categories 1, 2, 3, and 4, with the teacher no longer being able to make a referral to the office, that can no longer send a student who is guilty of a Category 1 offense. The teacher can no longer send that student to the office and continue teaching her class. She's got to stop what she's doing and deal with that offense herself.
Let me ask you one question
Yes, sir.
before you leave, and I'll ask you the same question. Can the language that you read from Polk be read consistently with the statute?
We believe it can.
Okay. Hear the rebuttal.
And I would argue it can't.
Y'all both been very helpful.
I think it comes down to this. Again, are we going to expand, what happened here, everything is a working condition? Teacher, teach to these standards set by the state. Attend this meeting this afternoon. At lunch, stand in the cafeteria and make sure nothing happens. Stand in the hallway between classes. Those are all instructions given to teachers. Under their argument, if they don't do it, they can be disciplined. Just like if you don't apply the student code of conduct, you can be disciplined. So what they're saying is if I don't do X,
Can't they be disciplined?
they can. But they're not being disciplined for the student code of conduct. They're being disciplined for not following those instructions.
Aren't we just playing with words here?
Yeah, we're not playing with words because what they're telling the court is, if I don't apply the student code of conduct, now I can be disciplined, so therefore it should be a working condition, just like all those other things I just mentioned.
Well, let me go back to my earlier question. If a teacher exercises his or her discretion in how the student code of conduct is applied, can that affect the teacher's employment status?
There's nothing under the student code of conduct that references how teachers would be disciplined for failing to apply it. It's not designed to discipline teachers. It is designed for students. And so you just heard under the level 1, it's the things to teachers to do. But what we're talking about is put that phone away. Stop talking. We're not talking about investigations about who started the fight and who hit. All of those type of things go to the office, and they were going to the office before, and they're going to the office now. These level 1 categories, the teachers were doing before. It's not an additional requirement. It may be codified and put down so it's delineated.
I believe opposing counsel said there are additional requirements now, though, aren't there? Under the new code, or under the new code of conduct, yes.
The social and emotional learning, the goal of changing the student code of conduct is less students get disciplined and less students get suspended. Hey, let's talk about why you didn't do your homework. Is there a problem at home? And so even with those level 1 categories, you can still refer those to the office for repeated infractions. So it's not that the teachers are asked to do anything more than they were doing before. And the legislature, and I think the important part is, the legislature did define, and they changed it and said, interpret these statutes narrowly, and whatever you do, you cannot include professional duties. They put in the statute under 495608B5, we're going to exclude professional duties. Part of that professional duty is managing your classroom, which may include discipline. So the expansion, what the court did here, that's the problem. We are not complying with the legislature's intent to narrowly define these terms, working conditions. It shouldn't be expanses of everything. And so the court should overturn the chancellor's decision.
Thank you. Thank you, counsel. We appreciate your argument. We will review the record and endeavor to get you an opinion regarding this matter at the earliest possible time. You may be excused.